One physically. The defense, they contacted you. They are on the way.
Yes, he just crossed the district council. It's 5 minutes.
What about Sinakara Kwesi?
They must be coming together only. Maybe.
With them?
I think they must be coming together. I'm not sure.
You said they are having a meeting. Hello? They are having a meeting. Only only legal it or the bar? She's what? In the bar. You know, in the scripture. She's what? She have to organize the meeting. She can go. Come from bar. What signature?
That disability certificate, which has not been exhibited. This was brought.
It's not as simple as you said.
This was
just to identify signature.
This was not brought actually because this came later.
I understand, but it's not as simple as that. Just to identify signature.
I understand.
They have to prove it in the satisfaction. Why do you put the signature therein?
Yes.
I hope you have done the brief.
Yes.
I hope the witness knows her purpose of her deposition today. To prove what? Call innocent, call.
Yes, sir.
Telling them call innocent.
You know, actually, I have two cases today. One is Tarsan Nontra for judgment, and the other one, Michael Wanyang.
Michael Wanyang,
for production.
Only for production?
Yes, sir.
Visited it. Why you are standing? You can brief the witness.
You know?
Brief the witness.
I have already done that.
What
there.
for she have to prove?
I spoke to the main person. She is just her digital signature is.
You have no knowledge or no knowledge.
Nothing such. And even the previous one, the main doctor, medical officer,
DHO.
no, she is the medical officer.
Psychiatrist.
Yes, the psychiatrist, she is saying that the BKT test was not done only. So some other test was done socio, what is the test? It was VSMS.
Which is for the child.
No, it's for the history taken about the child. Based on that, this some internal report they have collected, and based on this has been done.
Or they implement that other.
She will appear to BC.
Today itself.
She is
Today
exposed.
itself.
Yes.
Why are you doing this to me? See, I'm actually being transferred, no? Why you make things rush?
If I have known, madam, I would not have called actually.
I intend to only give judgment. Now, all these times, I've been expediting cases. And so many, around 25 cases fixed for argument. Nobody wanted to give argument with me. So the harvest, I have done so much to expedite cases. But I don't get to yield the harvest. And still you want me to cultivate further? No.
No, it's not that, madam. Well, this last occasion, after filing the petition, you said that you call all the 3 witnesses.
I don't mind. I
Yes.
don't mind. The thing is that the way you're rushing, huh? I have noticed the way you're rushing with the evidence, and you don't spare me even today that I have to collect all my things. Tomorrow I'm on the move to a new posting. Nevertheless, and today I have got there's so many bills, and all. I have to sign so many embassy. I'm not complaining. I'm not saying that is, but the thing is that in your own saying, I just feel now in a haste. If you don't read properly to your witnesses,
I spoke
the
to her.
case will flop.
I spoke to her much before. In fact, this expert.
As a prosecutor, you are to see to it that you prove the case. But then if you are willingly giving up the case, it's up to you. Anything now you do in a haste is dangerous. Unless and until you are 100% sure. That's no use. Okay, nevertheless. We cannot force any witness also to say things which is beyond their knowledge. So,
Apart from her, she also doesn't know.
yeah.
It is her only her digital signature.
Okay, fine. For her, okay, fine.
Yeah.
But for the other doctor,
The other
who you
doctor,
said is having so much knowledge, they have done some tests, they have done, it would be better to do
BKT
with
test
the
was
next
not done.
officer.
BKT
With the
test
next
was
officer, I feel. If you are forcing the witness to just give them, just give any way, anyhow, then the case will flop. You better brief properly, go through the file. I don't think you are so much well aware. You just came to know from the other witness just now. But it's not from your own
regarding this thing,
findings.
no, I had to talk with
You
her.
have
Also.
to prepare even with the case. Okay, sit. For the time being, it's up to you at risk. You are doing things. Come. Pasal nombor. Are you ready? Kita kan minta beri kasih, right? Kita kan minta beri kasih dengan air, right? Kita kan, bila orang lupa hayin, bila ready lupa. Lai thua na hayin beri kasih dengan air, right? Minta. Premier thua dia. Melalui kadang kau phone minta, shoot phone. Yes, no? Sure. Okay. I have gone through all the evidence in this case, your arguments. Okay, it's at length. Okay, argument. Nevertheless, from all the evidences that I've seen in this case, the apparent fact, there is no enmity between the accused and the victim admitted by the victim. It is all apparent fact. Incident would not have occurred had he not drink, but he was fully drunk, admitted fact by even victim. See, when the prosecution witnesses themselves, they prove the intoxication. So you don't have to. You don't have to prove any more intoxication because your prosecution witness, especially the victim herself, proved he was fully drunk. Okay, how the incident occurred here is because after his altercation with his wife, he was in an emotional stage. This is what is revealed from the evidence, entire evidence. He was in an emotional state. Okay, and the PW2, there are only two eyewitnesses at the PO, PW2 and PW15. PW2, he said, the accused came in search of his wife because this wife had run away from home because she got angry. He was fully drunk. Okay, so he came in search of his wife. Okay, and his wife, as PW15, she said he carried the gun around because he feared to leave it at home lest it will be stolen. That is the prosecution witness saying. Okay, he came with a gun. PW2 said he came with a gun. Now what happened? What happened? PW2 said he was sitting with the accused in the veranda. And altercation is a known fact. It's a fact. Okay, established. He was in emotional state. It's apparent on the face of record in the evidence. The victim came. After all this, after hearing altercation and all being neighbors, she came. Okay, I will not say that she came to meddle here, I don't know. But in the mind of the accused, who was already in an emotional state, he saw her coming. Then he said, you go home, why you want to meddle with the affairs, family affairs? But PW15, the wife of the accused, she said, the victim refused to go. It shows she wants to peep what is going on in family matters. In enragement, a sudden rage happened to the accused. And from the version of PW2 that they were sitting in the veranda and she came. Okay. So he said he pointed the gun at her and tell her, go away, go away. It's clearly, and no, there was no intention for criminal intimidation, no enmity with the victim. It's just a quite casual doing. Okay. And PW15 gives a clear version. The victim was in 15 to 20 meters away from the accused. So here in this case, it is only the victim who said he pointed a gun at my chest. She is the only one who said. There is no corroboration from any corner, from any witness, especially the two eyewitnesses who were present at the PO. So it's uncorroborated. Then he pointed at the chest. Yes, PW2 said he pointed the gun and said, chase away. It's a casual doing. Okay. So the point here is that for criminal intimidation is not fully proved to the satisfaction of this court that he intended to cause harm or criminal intimidation to the victim. So I give the benefit of doubt for 506 to the accused. Coming to the Arms Act, prosecution give up 25(1)(a) because it's not applicable. It's related to prohibited arms. But the arms involved here is open fact, is a licensed arm. Okay? Then you want to pursue with the case. Prosecution wanted to pursue with the case only under section 25(1)(b)(a), okay, of Arms Act, which is regarding the contravention of section 3. Section 3 provides anybody possessing, carrying, using arms without a valid license. Okay? It's a licensed arm, but the license has expired. Okay? So the license has expired. It is equating to it is amounting to no valid license. Equating to no valid license. Okay? So for that fact, you cannot claim that he don't know, ignorant and all, because a person who has applied for arms license, he has a legal duty to see to it that he maintained properly the arms. He maintained the arms properly, don't misuse it, and it is his legal duty to see, to renew the license. So ignorance of law is no excuse. Okay? So the only thing here is that I find, yes, it's true. I agree with the prosecution. It's amounting to possessing, carrying arms without a valid license. However, from factual situations here is that his arms license, the arms has been seized, the license has been cancelled. Is punishment enough? Punishment enough? Because he cannot get back. He can never take back the arms license, nor the arms. Once you violate, finish. Is punishment enough? The arms now is to be confiscated, seized for confiscation. So, is punishment enough? So, since there is a proviso on the section 25(1)(a)(b), 1(b)(a) Arms Act, that special consideration we can give to him to reduce the sentence. The sentence actually for 25(1)(a), 1(b)(a) is 2 years, not less than 2 years, not less than 2 years, and
Extend to 5 years.
can be extended up to 5 years. But the proviso, I feel, applies here. I've taken this special consideration simply from the fact is punishment enough. He'll never ever get the chance to have arms again. Okay? He'll never get it again. Once violated, finish. So for that reason, is punishment enough for him? So I have taken this special consideration, and let's hear on the quantum of sentence. But keep in mind, the court already considers special consideration. So we can reduce the sentence from 2 years down. Don't go from 2 years to 5 years like that, because the special consideration is to reduce. I find here, he didn't intentionally use the arms to point at the victim. Rather, it could be exaggerated fact from the victim, because he is uncorroborated. The two eyewitnesses, they never said, they never corroborate her that he pointed the gun at her chest. So uncorroborated statement I cannot accept. It sounds exaggerated. It's open fact here. The accused person is in emotional state. The victim enraged him with a sudden rage by her refusal to leave from meddling with the family affairs. So for that reason, he just pointed casually, go home. Okay, this is what I see. If you disagree with me, there is higher forum for you to go for a mission or for a B. Okay, let's hear on the quantum of sentence. Tarzan nong trao. मैं भावक cầm jubha này bao men right rồi bili men right rồi cái lên đấy tôi xin men right rồi mỗi in history on his statement he said out of drunkenness I carry. So it's open fact here in the evidence of prosecution witnesses that he was fully drunk. This is the big reason that it gave rise to altercation between husband and wife. Okay, then he arrived at the field because wife ran to the parents' house. Okay, so it could be true what he explained us, out of drunkenness. Okay, maintain mo katugusuloy kalakot ka license.
Yo page bakaya ka tarik manam.
Okay. May page baklay ng tarik.
Pagkat pag tarik ne. Page bakala tu panay.
Page. Katu gajing lek berngem jume ya ka. Ya tu kokong. Kani kokot ka ai ya me ka kabu ba ka atatin. Ya gajing kano joka. Nama ba me medon jing shun ba ka ko. So, melat na katu gajing lek berngem ya ka tak suloi ngala pelai. Ngala ai ya me da gajing atatin. Muk nga atatin ya gajing kano tu kokong. Kaya pelai ya me section sanspan tu kepada ya gajing lek berngem beriu dak suloi. So, kadba ka anpat kate mendoong ket yakta kanaruk mlak reban map dak parengyo ignorant some social skills kemut haba ka don hi ka duty jo me siti me yo e ka ans ka duty jo me bamen pet bhai ka to men smart bhai ka men pet ban pet kam bakla baba men pet bha ka license ka kut meno ban mendang bakla ya kata ka jing bakla mlak reban map kata ka ka an so tu namat kata ha pahi ban ajing pitsto mi me ya ka jing bat ya kasuloi kan don license namala na ba ka license ka badan kalayak kemut kalalong di bang don license so tu ega tu ka license cuma ru kilapan kut kilakan sel so tu bat ketuk suloi ru kilakan ni memlashu banyo so memlashu I cannot pass any order to return to him I can return him any other things by motorcycle or car or whatever sees but not the arms. The law do not allow. It's now only for confiscation. Okay. Take. Jump. Okay. Prepare the order, okay? Namaba section 14 of the Arms Act do not allow for renewing of the license when it has been found we had violated section 3. Okay. I mean this section 14. Oh, come on, Ramo. Sorry, 14 is that whether he has violated any bond to for public to maintain public peace. Prosecution commander nevertheless, the ani kamsha. No, kamsha sure but yo. Nevertheless, let's hear.
Since the court is willing to go to the proviso of this section 25 1BA, so I have to pray for 2 years punishment, Yana, with a fine of 50,000 rupees.
Submitted. Read that maximum sentence of rigorous imprisonment of 2 years, ma?
Yes, Yana.
Of 2 years. Okay, read that that on station on But tadi kita kat nolak dan sama. Maximum sentence of imprisonment of 2 years. With fine of rupees?
50,000, Yana.
50.
Yes, Yana. To be given it to the victim, Yana.
Why? Why to give the victim? I didn't find any.
Because of the trauma she had experienced, Yana,
No, I didn't
regarding
find-
that incident.
I didn't find anything done harmful to her. I didn't find any harm done to her. I didn't find. Rather, it is a possibility here also. She has been influenced. Delay of Ramayana, I find it's a possibility here because I didn't pronounce something because it's a so wrong judgment. I even agreed to some extent also there could be influence from the village people also to the victim. Now why she waited for so long? See, if you fear so much about arms and all, na, immediately rush to police. Because arms is what? One shot, gone, finished, died. But still, why you have to wait for so many days after consultation with villagers? Then come up with the application. And some witness, they said that he is a troublemaker and all that. Yet, no proof of such. No complaint. They admitted there was no complaint of any earlier doing. I'll just skip that one. Or you still insist?
It depends on the code, but from my side, I have
I don't see
submitted
how.
like that, That is my submission, but
You want me to enter?
yes, That is my submission from my part.
Why you said it has to pay to the victim?
Yes,
Why? See, it's like this thing. Why you are submitting like this? When I disagree with you that there is 506 IPC.
There's no prejudice.
Now we are only determining the quantum of sentence for the Arms Act. Then why you want to go against, like, it's so very,
Yes,
it's like you should directly to me. I disagree with you.
Disagree.
You disagree, go to High Court.
Yes,
Why you want me to reflect?
Okay, then it's better to cancel that point,
Because I don't find anything against. No harm done. She's at a distance of 15 to 20 meters. Okay. Okay. What is your say?
Your Honor, since he has already learned his lesson.
No criminal antecedent.
Yes, Your Honor.
Cooperative investigation trial.
And he has already
Supply bail applications, conditions.
and he has been in
Never tamper evidence. Okay.
and he has already been in jail also, Your Honor, for 3 months.
And has already been in jail for more than 3 months.
And after release from jail, Your Honor, he went to ask for forgiveness and
On his release from jail, he went to ask for forgiveness from victim,
from everyone, Your Honor. In fact,
from everyone.
yes, Your Honor.
Okay.
And therefore, Your Honor, I would like to pray only for 3 months imprisonment only.
And since his arm has been seized, and since his arms has been seized, and his license cancelled,
Yes.
hence she prayed that he may be awarded with only months imprisonment, huh?
Yes, Your Honor.
Fine. And fine of rupees.
1,000, Your Honor.
Huh?
1,000, Your Honor.
One. convicted person may explain with the judgment in his Khasi language. He submitted that how old is he asked?
No, 44 years.
44 years old. Rayu.
Rayu.
Langsung.
Kamay ka na si.
Kanabi kamay si.
Spa. Kanungot ko.
Kanungot pidang kon. Sawon.
Ano ba basahin ki?
Ano ba sa iki? Okay.
And he submitted that he mistook the date for renewal of the license. You already said, okay?
Yes.
Of the arms license. Beliau boleh buat sih.
Itu kasi baca tu jeng ada, balik kira itu kasi sudah jeng ti.
Susu lah. Right.
License and ông đưa là ula hadu kat ban supaya
Ada kalau tidak fine apa kot. Masih fine apa kot. No. Tak masih.
Karena
hồi giàu đó
Sepuluh lah. Hah? Sepuluh lah isi kot.
okay under submissions considering all aspects with the accused each as well as the fact that he's carrying the cause of the confidence as admitted with the necessity of the victim. However, his possession of firearm with the expired license is not an excuse under the law. Okay. Kalau Alif ko ni charge battery. And that his possession of firearm with an expired license is not an excuse under the law to absolve him from his legal duty to know the exact status of the license of his firearm in his possession. However, this court at least had given him the special consideration as per proviso under section 25(1)(b)(a) Arms Act to reduce his sentence, and this court doth hereby awards a convicted person with sentence of rigorous imprisonment of reduce his sentence since his ceased arms will be confiscated and arms license cancelled. Cancelled. And this court shall by awards to convicted person with rigorous imprisonment, or you have to go for some imprisonment, at least pension, not to make such mistake anymore. And we'll find out these 6 months, rigorous imprisonment, fine of rupees 10,000 only, and in default thereof, he shall undergo simple imprisonment of 1 week. The awarded fine amount, if paid by the accused, the same shall be deposited with the treasury. Sometimes we are also to contribute to the state fund, to the treasury under the head of fines and forfeiture. His detention period since his arrest on Kanutari. His arrest on 12/05/2022 till his release on no freaking only took Kanyo 08/2022. So they got no banana, no, which is Libanai Sanski. Okay. Is hereby set off, and the accused is to undergo the remaining sentence period. Kung sasakat mo pa dala 6 months. Let a copy of this order and judgment be supplied to convicted person free of cost. Let a copy of this judgment and order be supplied to district magistrate superintendent. This order will form part and parcel of the judgment. Issue order of commitment on the sentence herein against the convicted person. With a copy of this order be supplied to superintendent of district and correctional home for information necessary order. Case stands disposed of on contest. Okay. This is my order. If you disagree, go for P. Any corner from anyone. Kamu unsa sa kano ba ayo? You have to go. Nanabi siyang jiri. Hindi. Supo. Nabi siyang jiri hindi. Namar. Malian ka rasuro, malian ka dikya. Kaya ko balapin sliwe me. Kaya ribo pun po jiri ko me. Masto, bapun podcast kami. Masto, wajule class no, wajule pen jenjar beri, wajupin kulma nanti me jenjar nanti me ban podcast. Kalau kikun la jenjar ulok cer podcast kila jenjar, tang batoi, ngadang perkat, menyo songjil tak hendak, mende songjil sakat no ane thai. Lai benai duna. Arbanai absensi eh. Nah habis mat ikan dia itu cinglet cuma man Malaysia. So that is my judgment. Battery. Shim. Kalau nak kerja saya aku pilih.
Good.
เป็นพวกน้ำชิบายินจะรู้ปันน้ำบะพนมาเอาหน้าไปชงจีรีเรื่องตัวรัวไล่ประเด็นนักสังเกตสบายเอามา
Yes, Your
อั
Honor.
นเรื่องตัวเดินชงนิวส์แลมอันรู้กันนะ 7 years นะ
7 years.
7 years เดินชงนิวส์แลมตัวนี้ช่วยอูนี่เป็นช่วยเอ็ดอยู่เนี่ยมันช่วยตั้งแต่จริงเอ็ดอยู่มาโอเค
Good.
good day I can please immediately. Michael Wanyang, Ricky Paul Snaitang, Paul Andrew, Meglan. So, natang sini taman chuan penmi. Kalba kisaki kena kakui katarik nama kakam jinga shnong kena poi nata. Niap ai por ani seki ap sausi ban poi kakot chiki. So, kade taman chuan penmi kumne. Kasaki kade koi kasni. Pleno. Okay. Accused owner, produce. Yes. DDN, thank you, ne?
Yes, ma'am.
DDN, thank you, is absent. Additional PP is present. Accused are remanded for public case on the date or fixed for evidence on
11 September, ma'am.
11 September. Yes, thank you. What shall we do? Pin evacuate. Can put a more difficult judgment and people feel that Hanan would not. Mamanta keep a table rakum de saliate and then they. So then you can put the roof up on one track, you could have I took it. Don't love me, it's not it. Let's see if I can put it here. Could I put it in that? Wait a minute. Pass over and talk to you, see that? I need your paper.
Yes, ma'am.
Saya bakal siapa? Om yaki makin apa deh? Apa nak apa dia ni dalam kapasiti polos setri ada 50,000 nanti. HCC. Written ayat show finance data system.
Okay, ma'am. Good evening.
Accused Adana Nata is present and another violation is present. Judgment and order. Judgment and order. Cut pages. 25 pages. Delivered and pronounced in open court today, by which the accused is acquitted with benefit of doubt on the charge under section 526 IPC, however, he is convicted under section acquitted under 526 IPC for benefit of doubt. It is under section 25 1B A Arms Act, with the special consideration as per its proviso, as discussed in the judgment. From VA to take steps to judgment enter. Both sides has been heard on the quantum of sentence. An order of which has been passed at page number. At page number 46. 45 का judgment का order break 46 to 47, continuing from the judgment being its part and parcel full stop. VA to take steps to all concerned as per direction therein. to take step to all concerned as ordered in the judgment. To take steps to take to take steps to all concerned as directed in the order in the judgment. In the judgment was not enter, case stands disposal on contents. Where the accused has been awarded with 6 months rigorous imprisonment and fine of rupees 10,000, which is detention period during investigation, which is 3 months and how many days? And 5 days? And 5 days? And 5 days set up. Has been set up. Has been set up and is to undergo remaining sentence period. Sentence period. Full stop. Done. Sentence periods and five days. 5 days. 5 days has been set up. Okay, this period. And if he fails to pay fine, to undergo 1 week civil imprisonment. Okay, now we'll have evidence.